Good afternoon.
Good afternoon. Everyone's in a different seat, so
Not Trish.
No.
And you've got the same.
Yeah.
keep me on my toes. That's right.
You've got the same seat.
That's the best one.
Yeah. Well, welcome, Mr. Ostergren. We
Thank
are
you.
happy to have you here today, and we're going to let Ms. O'Brien get seated. And as soon as she's seated and
Very
you're
good.
comfortable, would you please make your opening statement?
I will. Let her get situated. And
Yes, thank you.
I should have prepared a few jokes to. There you go. So, well, good afternoon. Thank you for your service again on this commission. I know it's turned into probably a bigger time commitment than you may have expected when you first ended up on the commission. So, I'm still Alan Ostergren. I'm still the Muscatine County Attorney. I've been a lawyer for 22 years. I've been county attorney now in my third term. I love being a lawyer. I love, in particular, the people I get to interact with in my office, in the law enforcement community, at the courthouse, opposing counsel, crime victims. One of the great joys of my job is the variety of people that I get to interact with every day in serving my community. I'm going to go back to something that we've talked about before, and that is, in my view, and the view of I think a lot of people, that the court would be benefited by a criminal law practitioner. And to that end, I've had over 100 felony jury trials in state court, which I think speaks for itself in terms of the breadth of my experience and the responsibility that I've carried throughout my career. I've also, as you know, taken a leadership role in my state association for county attorneys and starting an amicus curiae committee, and have written about 12.5 amicus curiae briefs for the Iowa Supreme Court. I know, and I've heard from quite a few commissioners, that there is a thought, which I certainly understand, that prior judicial service is something that many commissioners look to. And there's good reasons for that. I would submit that what I do as a county attorney is no less valuable to you as a selection criteria than were I a current judicial officer, in terms of the vetting process that you go through to be in my position, in terms of the responsibilities and kind of decisions that I have to make day in and day out. It's certainly not less than what you would get from me if I was a judge right now. We could have a spirited conversation about if it's the same or more, but it's not less. One of the things that's a challenge for when you're a prosecutor trying criminal cases is, unlike lawyers in the civil context, we always have the lingering issue of, is the attorney on the other side of this case doing his or her constitutionally required function as a defense lawyer, the specter of ineffective assistance of counsel. So one of the challenges of being a prosecutor is you're always thinking about, am I trying my case appropriately, but also is the defense lawyer trying his or her case appropriately. You want to, obviously, when you go to court, you decide you have a righteous case, you want to win, and that's a natural thing for any lawyer, but you don't want to win by bending the rules, let alone breaking the rules. And quite frankly, you want to make sure that the court gets it right as well. So unlike what a lot of lawyers do in other contexts, when I go into court in a criminal case, I'm not just trying to keep myself straight and narrow. I'm trying to make sure the defense counsel and the court are doing the same. So you've had a chance to talk with me one format or another and see my materials. I'm eager to hear your questions and do my best to answer them.
Well, thank you.
Thank you.
We do have some questions. We will begin with Mr. Sukup.
Thank you, Madam Chair. Mr. Ostergren, there was another individual earlier today that county attorney as well, and they said they mentioned one of their biggest humilities was being involved in a lawsuit. What would you say would be one of your humilities or learning experiences?
Trying cases, big and small. My first jury trial, which I lost terribly as a prosecuting intern here in Polk County, it was bad enough to lose, but when the defendant asked Judge Pilley for the marijuana back, I thought that was really not really as spiking the football. He said no, thankfully. So, I think you have to, if you're going to approach the job the right way, you have to realize you're going to talk to people from all segments of life, and we deal with people in the criminal justice system all the time who've been looked down on their whole life. Defendants and crime victims. Over my career, one of the most valuable compliments I think I've ever been paid was by a crime victim. We had convicted a man who had sexually abused an adult woman after hours party. Everyone was drunk, and he groped her, penetrated her digitally. And at the end of that trial, he's been convicted, and this lady had nothing in life. She wore the same thing to court 3 days in a row to testify. And she said to me after the trial, nobody in the system has ever cared about me until I met you. That kind of thing means a lot to me. It's why I do what I do. It's why my colleagues do what they do, because you get those opportunities to show to somebody that people care, that I'm not looking down. I'm wearing a suit. She's wearing clothes that smell that she got from somebody else, but I'm going to treat her like a human being and fight for her.
Thank you.
Ms. Valentine?
Thank you. Somewhat along those lines, do you agree that there is implicit bias in our system? If not, why not? And if so, what do you think the court can do to address that?
Right. I wouldn't confine it to the system. I think there's implicit biases throughout society. We, as county attorneys, we got some pretty valuable training recently on implicit biases and whether or not we're doing a good job as a legal profession, and I think there's room to improve. If you look at implicit bias in the medical field and differences in outcomes based on race of patient and things like that, it's shocking what you see out there. So as a court, what the court can do is not to be afraid to talk about that as an issue, to keep that dialogue going on. It's not something that you're going to solve by just simply, well, we had training and that's it, we fixed it. It's an ongoing commitment to equality under the law. And equality under the law, it has to be more than just a slogan. It has to be, thousands of little decisions that get made all over the place to ensure that you have a culture of treating people with equality and respect and fairness while you are applying the law and doing what the law requires.
Thank you.
Thank you.
Mrs. Sinclair?
Have you ever considered applying to the district court?
I have done so in the past. I have applied. I'm sort of the point in my career where, thinking through what I do now and the opportunity to serve on an appellate court, this is the interest I have right now. Being a county attorney, I'll be blunt, I think is a lot more exciting and interesting in some ways than some of those other opportunities in the trial court for me. And I don't say that trying to denigrate those on the trial court. In terms of what I am interested in doing, I see an interest in serving in an appellate role. It's not really for me at the trial court level. Some of it is just practical. I live about as far away from the courthouses in my district as you can right now, and just what I enjoy doing is why I'm here and not applying for the district court.
Thank you.
Thank you.
Ms. Conover?
Along those lines, Mr. Ostergren, you interact with the district court every day. You see the challenges that our district court is facing. From your perspective, where you sit, what can the Supreme Court do, or what should the Supreme Court be thinking about doing to try to support that district court bench that is sort of out there on the front lines of our judicial branch?
Right. So I think there's twofold. What can the court do in deciding cases? And I think that is to be keenly aware of the work that district court judges do and understand the difficulty and the time pressure, and it's hard to get good orders out quickly, and we need to be understanding of that. I think institutionally and administratively, the court needs to be engaged with the legislature in ensuring consistent and predictable funding for the judicial branch. There's a lot of demands for money across the street in a $7.8 billion budget. Big chunks of that budget are sort of on automatic pilot. The court budget's not. So that's certainly one area where I think my experience in working on legislative issues through the County Attorneys Association would be helpful to the court and to that mission, because the court has to keep the lights on, it has to keep the doors open, and and I'll add something that to your question. We need to support district court judges when they're in the biggest counties and when they're in the smallest counties. We need to have this access to justice, urban, rural, micropolitan, you name it. We need it across the board, and so the court has an important role to do that, and I think my skill set would really line up well with that need.
Mr. Berger. Mr. Goodman.
Mr. Ostergren, there's been a lot in the news about stop and frisk, and that's a doctrine we have in Iowa. It's a doctrine that's in other states, and I'd like you to comment on what the Iowa law is, what the New York law is, and why there is the controversy there is. I don't know if the law is different in New York, or it's just being ignored, or why is explain that to us from the criminal background.
So it's like bar prep to be here. So the case is called Terry versus Ohio. So if an officer has reasonable articulable suspicion that criminal activity is afoot, which is kind of an old-fashioned way of saying something's up, you have something that you can describe more than just policeman's hunch, okay? Then you can do things that are short of an arrest, short of a full-blown search of somebody, in order to see, principally, do they have a weapon. Now, I think the controversy in New York was that the New York Police Department was tasked with stopping and frisking a neighborhood, not necessarily stopping and frisking individuals. And the important thing is that there is nothing wrong with law enforcement having specific information about a specific person and their conduct and investigating that appropriately, versus having sort of this us versus them mentality. Law enforcement has gone through, I think, a different philosophy on this, of sort of this warrior mindset. And I think the better mindset, and what I like to see locally with the people I work with, is more of a guardian mindset. We're not patrolling the streets of our communities like it's Fallujah. We're patrolling it like we live here and our kids go to these schools, and we respect this community. So I think we're doing it better in Iowa than they were doing it in that example you cite.
Thank you.
Thank you.
Mr. Bloom.
No questions, thank you.
Mr. Bevel.
Mr. Ostergren, when we talk about implicit bias, we look at incarceration rates, stop and frisk. I wonder sometimes if that's not influenced by the fact that law enforcement, prosecutors, even defense attorneys, their contact with minority communities is limited to the criminal justice system. If everybody you see is a defendant, you start thinking everybody's a defendant or a crook. Right. Can you tell me about some of your experiences with the minority community outside of the criminal justice system?
Sure. Well, I represent a very, as things go in our state, a very racially diverse county. Muscatine has a relatively high Hispanic population, many of whom are third and fourth generation living in Iowa, and then people who are new arrivals. So, I share the sensitivity, and I'm on a. I've heard that sentiment, I think, well said in other contexts as well, that it's very toxic to equate minority with criminal in your, if you're thinking about minority issues, that means you're talking about criminal issues. That's what we need to avoid. And one of those things that makes it implicit is it's just sort of this manner of speaking and manner of thought that I think it's helpful to be very clear that that's not, we're serving an entire community. And many times, and I've said this to my peers, I've said this in public settings, you can look at statistics of minorities in the criminal justice system. One of the things that I want people to also remember are minorities who are victimized by crime, that the community that we are protecting has people of all different kinds of descriptions and backgrounds and characteristics, and that we need to be thinking about we're protecting everybody in our community. One of the disparities that we don't talk about enough are if you are a racial minority in this country, your chance of being the victim of crime in general and violent crime specifically is far higher. And so, I think we all have to be aware of that in the system.
Thank you. Ms. Law.
No questions, thank you.
Mr. Spies?
Good afternoon, Mr. Ostergren.
Good afternoon.
Good to see you again.
I see you.
I think you and I have discussed this before, and if so, I apologize, but a committee of the federal judiciary has recently drafted a advisory opinion that would advise federal judges to withdraw from membership in the Federalist Society or the American Constitutional Society. I know, of course, you're a member of the Federalist Society and you hold a position on the steering committee. I don't know if you're familiar with that advisory opinion, that draft opinion, but wanted to know, number one, if you would consider it important as a justice of the Supreme Court to withdraw from your membership, or number two, whether your membership has informed your position on issues of constitutional significance. Sure. That's a softball question, isn't it?
It has informed my learning about the Constitution in many ways. The advisory opinion, I am familiar with it. It actually says that federal judges should not hold leadership positions in those organizations, but does say that there's nothing wrong with judges attending seminars and speeches and things of that nature. I'm not going to do anything, if I'm serving on this court, that would jeopardize my ability to be an independent justice of this court. Now, we take it as a given that justices and judges can do things like attend Iowa Bar Association events. Every summer, the judges have their annual meeting literally in the same place as the Iowa Bar Association. And the Iowa Bar Association has lobbyists across the street right now taking positions on bills and advocating for particular policy views. And I don't think anybody would think that judges are losing their independence because they do some training alongside lawyers at the Iowa Bar Association or anything like that. Now, I think whether it's the Federal Society, American Constitution Society, the Bar Association, or any group, a judge has to be very sensitive that nothing that you're doing participating outside of the courthouse in life would be interpreted as influencing how you would decide a case as well. So, hearing somebody give a speech, I don't think does that. Taking leadership roles in any kind of organization, FedSoc or ACS or anything, I think would have to be decided on a case-by-case basis, but I'm not going to jeopardize my ability to be independent.
Thank you.
Thank you.
Mr. Horbach?
I have no questions, thank you.
Ms. O'Brien?
No questions, thank you.
Mr. Hoytik?
I think whoever sits in the seats as Iowa Supreme Court justices in the years to come have a lot of resolving to do with Fourth Amendment and things like cell phones. And when the Fourth Amendment came about, there were not cell phones. There were not the level of technology that exists today. May not have even been in the realm of possibility for our framers. Do you have experience dealing with those issues? Have you been trained on electronics? Do you have any computer programming experience or anything that you think would inform you to help make those decisions?
So electronic evidence is something that we deal with regularly as prosecutors. I can think of a murder case I had last year that we won largely because of getting a search warrant and getting into the defendant's phone. Cell phones have become a really important issue because they've gone from merely being some piece of property to, you know, your papers and even the contents of your most intimate thoughts, right? It's trust me, people will put a lot of stuff on their own cell phones that you wouldn't think that they would. Maybe you would think they would, but as a prosecutor, I can tell you, I need eye bleach sometimes when you look at cell phones that we've seized. The court has to be very sensitive to balancing the need to get relevant evidence and law enforcement just searching things willy-nilly. Just because you can get into a phone, does that mean that you get to search every single email, text, picture, video, et cetera, on the phone? Versus you can find really good evidence that might exculpate somebody also. So I am sensitive to that. I mean, and frankly, my career has spanned that time period. When I started as a prosecutor, cell phones were these giant bags that weighed, 10 pounds. And literally, if somebody had a cell phone and they weren't an obstetrician, that was kind of like evidence they were a drug dealer, right? And today, everybody has cell phones, and they contain all kinds of amazing information. The Constitution protects all of that. And one thing that's important is, people throw around terms like originalism and yes, cell phones did not exist when the Iowa Constitution was ratified, right? The Iowa Constitution fully protects cell phones, just like free speech protections in our state and federal Constitution protect your ability to get on Twitter and communicate your viewpoints. We are not bound by the world as it existed in 1857 or 1787 or any date where an amendment got ratified. So I see my time has expired, Madam Chairwoman.
Well,
Ms. Stanger and a few others have been missed out again. So
they've been very patient. But thank you for being here today.
Thank you.
Thank you for taking time to answer questions, and we wish you well.
All right, my pleasure. Thank you very much, everyone.